about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. The law office is open, as I like to say, on a Saturday morning. If you have a legal question, you have a toll-free number. You can call in at 877-943-9673. That's 877-943-9673. Your question can be just about any area of law. Can be about wills, trust, probate, guardianship, power of attorneys, healthcare surrogates, living wills. Can be about real estate matters. Can be just problems at the work, problems on the job. If you have a legal question, again, the toll-free number is 877-943-9673. And we are open to help you with a legal problem or a legal situation, answer any questions you might have. Be more than glad to help. A lot of times, a lot of the questions we get are on estate planning. So I always like to give a few little tidbits about estate planning. And if you need some help, maybe you have one of the most often questions that I receive about estate planning is what to do if you have an out-of-state will. So I had several new clients come in this week that had out-of-state wills. So we look at them and talk to them a little bit about it. Most every will that you have that's out of state come in from another state. Of course, the very first sentence in the will says that you are a resident of another state. A lot of wills have references to statutes in your old home state. A lot of wills are not witnessed or notarized properly under Florida statutes to make it what is called self-proving. Self-proving in Florida means that it's witnessed and notarized in a certain way with certain language. And that would prevent, if it's done properly, that would prevent ever having to find or locate the witnesses from your other state. Now, a lot of times I see wills done when you had minor children many years ago in another state. So you've named guardians for your children who now are way past 18. And you didn't name them as personal representatives or executors, it's called in some states. And the will just really needs to be updated and changed for multiple reasons. Might not comply with the self-proving statute. Might not want to use the personal representatives. You might not even be able to find the guardians you named in it. So a lot of times people with really old wills from other states really need an update. So, hey, find your will, dig it out, look at it. You can easily probably tell if you need some changes in there. If you have a question about your estate planning documents or if any other Florida law, you're listening to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. We have 20 office locations around Florida. We have 7 other attorneys who do multiple areas of law. We're here to help you answer your legal questions. This is a live show where you call in. Your question does help a lot of other people who might be listening. And you have a toll-free number you can call the show. It's 877-943-9673. That's 877-943-9673. Phone lines are open. We're broadcasting today from Tampa. We either broadcast usually from Tampa or Jacksonville, kind of on a rotating basis from week to week. Today we're broadcasting from the Tampa studio. If you're listening in Jacksonville, for example, you're listening on 600 The Answer, WBOB. If you're listening in Tampa Bay, multiple stations in Tampa Bay that carry the program. Stations include 570, 910. They include 860, 930. These are all AM stations. If you're listening in Haines City, you're listening on 90.3 FM. You're listening on multiple stations around the state of Florida. We have a community station in Sun City Center, FM station, community stations there. We have stations, other stations around the state that carry the program. But if you're listening, no matter where you're listening, you have a toll-free number, which is 877-943-9673. We're going to go to J.D., our first caller today from Sarasota. Hey, J.D., what can I do for you?
Good morning. Yeah.
Good morning.
I'm having a little problem, or I should say it's a big problem, from the association. It's a co-op here in Sarasota. I'm not going to mention the name, but it's strictly a 55 and over community, deed restricted or whatever.
Okay.
And I found a very good friend that said, hey, why don't you just live with me? And because they do allow people that are cohabitating, one of them to be under 55 and young as 45.
Mm-hmm. Is there a certain percentage of that allowed in the park? It's not everybody could do that, right? JD, are you there? All right, so I guess JD dropped off. JD, call back. I'm not sure what happened there, but if you have a legal question, you can certainly call in at 877-943-9673. And generally speaking, some parks have different rules, and certain percentages of some residents in the community can be under 55. It really kind of depends on the circumstances. But if you have a question about that or any other area of law, a lot of the questions I get about estate planning are who should be the personal representative or trustee of a will or trust. Should it be family members? Should it be professionals? Should it be corporate, like banks, attorneys, CPAs? Who should handle the estate? We know every family is a little different, and in most cases there could be a different answer just based on circumstances. If you have very astute children that all get along, and you want to treat them equally in the distribution, like 50-50 outright, just give it to them, no matter what the value and size of it is. You just like for them to have it because you know they can handle it well. Then you might choose them as the personal representative trustee. If you have children that would squander the money, spend it quickly, unwisely, be influenced by other people, and you want to stretch it out, then it might be professional. It might be better to have a professional trustee, either an attorney, corporate trustee is the answer. Let's go back to JD. Hey,
Thank
JD.
You. Yep, thank you very much. Sorry about that.
Mm-hmm.
Okay, we were at the co-op, and the lady, she's an owner of the park, which is 164th owner. So she doesn't own the land underneath it, but she's part of the co-op. And she's also vice president of the board.
Mm-hmm.
Well, unfortunately, one of the board members, has to be president, is really after her and had problems.
Hey, have you read the rules and regulations of the park?
Yes, yes. And what they claimed in the lawsuit, because they're evicting both of us, is that she is subleasing.
JD, we lost you again, I guess. JD, if you can listen to me, though, if there's a lawsuit involved and you're already represented by an attorney, it'd be improper for me to help you anyway. So if you call back, I'm going to have my producer ask you if you are represented by an attorney, and if so, then it would be improper for me to get involved in a short conversation with you with limited facts and try to give you advice. If you don't have an attorney, then that's another issue, and we could probably discuss it a little bit. You're listening to Ask an Attorney, all about Florida law. If you have a legal question, you have a toll-free number, which is 877-943-9673. That's 877-943-9673. Phone lines are open, and we are more than glad to try to help you. Your question probably helps a lot of other people who might be listening to the show. Give them a little guidance, a little peace of mind. And we are certainly glad to help as many people as we possibly can. Again, the toll-free number is 877-943-9673. And phone lines are available. Let's go to Harriet calling from Tampa. Hey, Harriet.
Oh, shucks. That.
All right, Harriet, are you there?
Trying to turn it off. There you go.
All right, go ahead.
Yes. My name is Harriet. I have a question about a dispute I'm having with a very nationally known roofing company.
Mm-hmm.
What happened during the hurricane we had back in 2017? Part of my roof came off as far as the facade part, and it exposed some rotted wood. Well, we come to find out after investigating, we found out that we couldn't get it covered by insurance. It was basically a builder's way they made the roof. The way they constructed it was incorrect, so that meant it had to come out of our pocket. So we got some estimations from about 2 or 3 roofers, and we finally chose one of them. Well, with that coming about, with that situation, we met with them in October, and we said what we needed because we already knew what the roof was because the other roofer had actually gone on the roof and walked it and said, well, it's rotted, and you have this all the issues. So we were aware when we spoke with them initially what we needed. So we told them what we needed. We signed a contract with them, and we asked them one specific thing, a couple of specific questions about how long will it take, knowing how Hurricane Irma did a lot of damage. We didn't expect it to be done next week. So we knew it was going to be at least maybe like 6 weeks or so. So the time passed, and we didn't really hear from them. We ended up having to call them and call them and call them. Well, they finally said, we're going to come and we're going to put 27 feet of siding on there. Now, they hadn't taken the roof off to see what the damage was, and they put the siding on there. And they said they want to come and start working on the roof. Time passed again. We're calling and calling. We go out to one of their locations trying to talk to people. And then because they wouldn't respond back to us, they finally called us. And they would say they were coming. They were having some issues getting crews here. When the crew would come, they would quit or go somewhere else where they would get more money, whatever excuses they could tell us. And we were still having it. We weren't getting anything done. So finally, I guess after probably several complaints from other people, because I was about to start my complaining to the state, they offered to cancel the contract. And they canceled the contract, and they said in that they gave me back all my money because they started charging me for, I guess, whatever they had did. So we end up with another roofer. The roofer came in, took off the stuff that needed to be done. It was very rotted all the way around the outside and all the way on the top. And so we thought, okay, we're done. The roof is done. We're fine. I start getting phone calls from them about something about a certificate of completion. And I said, well, I'm not going to do that because you didn't do the roof. Why would I sign that? To me, I'm signing a legal document saying that you did the job and you didn't do it. And I kept telling them that and everything else. No one explained anything to me at all about anything. They kept telling me that. I said, no, I didn't. No, that's...
All right, Harriet, I can't talk to you the whole show, so you need to ask me a question.
Well, I need to
I can't listen to you for the whole show. So.
Oh, I'm sorry. I didn't
that's
know
okay.
I realized I was talking to the other gentleman. Oh, well, anyway.
Well, he wouldn't have time either, actually, so.
Oh, that's true. Oh, okay, I'm sorry. Well, anyway.
Can you just ask me a question?
Yeah. Well, anyway, I needed to see whether or not your company does anything about sending a letter for any sort of dispute on that.
We have a real estate attorney that'd be glad to probably talk to you and see what you would need, and if a letter can fix it or state your position, fairly simply.
Right.
If you're being asked to sign something that's not true, of course we wouldn't ask you to sign it. We'd send a letter telling them why you're not signing it.
They're also trying to come after me monetarily wise now, and they're giving me some sort of...
Yeah, so if you want to call our number, it's 727-586-3306, and go to extension 116, and that's Jim.
Extension 116.
That's Attorney Jim that does real estate matters.
Attorney Jim. Okay, I'll give you a call Monday.
All right, Harry, thanks.
Okay, appreciate it. Thank you.
Bye-bye. Let's go to Carol in Haines City. Hey,
Hello?
Carol. Carol, are you listening to 90.3 FM?
I am.
Yeah, I'd heard that they had played replays the last 2 weeks, so I'm glad it's live today.
Well, it is.
All right, great.
Okay, I have a couple questions. My first is that I have an 84-year-old widower friend who is contemplating getting married to his girlfriend that he's been dating for over a year. The problem is, or so some think, is that she's 50 years younger than him. Okay, he has a will leaving his possessions to his children. She is a widow and has no children. Now, if they marry and she has agreed to a prenuptial, will she still get the 30% of his estate?
Well, if the premarital is done properly, he would have her waive that right.
Okay.
So a premarital basically says we agree that what's mine is mine and what's yours is yours, and you waive your rights, your statutory rights. The statutory rights that are waived are the 30% and life use of the homestead. And also, if you don't have it in there, they could sell the homestead, take half the proceeds.
Okay.
And they could get 30% of retirement accounts and things that are transfer on death or have named beneficiaries. They could get 30% of all that. So properly drawn premarital agreement, she would waive all of her rights to that, and he could leave his money to his own children.
Okay, because he really, does not have a lot of money. Actually, his estate is probably valued at $20,000 to $25,000, so it's not a lot of money. Does that will, even though it's that small, still have to be probated?
It depends on how his assets are titled.
Oh, okay.
So if they're titled with the beneficiary or co-owned with children, they would not have to go through probate. If he dies with anything just in his name, not jointly held, not with a beneficiary on it, then that would go through probate, even if it's a small estate.
Okay, but if everything is in his name, it doesn't have to be probated then.
If everything is just in his name, it would have to be probated because then then it would be in the name of a deceased person.
Okay.
So.
Okay. And
now, does the woman that he's marrying have money?
She does not, but her family does.
I see.
Yeah. And obviously, being that much older than her, chances are he'll go before her.
And is she willing to sign a premarital agreement?
Yeah. She said that she would be willing to do that.
Okay.
Yeah. Okay, so you don't think there'll be any complications then after he passes away because of the will and the prenup?
Not if she signs a valid prenup where she waives her rights to all of his estate, yes.
Okay. No problem then. Okay,
all
great.
Right.
Well, thank you for answering my question.
Thank you.
Bye-bye.
Sometimes after marriage, a premarital agreement can be, if, for example, in a case like that, he marries her, they have a premarital agreement, but along the way, she gets her name on accounts jointly. So now her name is on the account. It doesn't matter what the premarital agreement says. If her name is on all the accounts, she would be the new owner of the assets. And I have seen cases, I don't know anything about this particular incident, but I have seen cases where after marriage, everything gets changed to joint ownership and the premarital agreement's out the window because how it's titled is what controls. Let's go to Mark in St. Petersburg.
Hello, Joe.
Hey, Mark.
Hey, good morning. I had a question about being evicted. I think I know the answer. The time is, I think you said 30 days to somebody if you're being evicted without a lease. And I just wanted to know the process, the logistics of, do they need to do it in writing? Can it be over an email? Can it be verbal? Because
well, are you the landlord?
No, I'm the tenant, and
well, it should be in writing.
In writing. Okay.
If you're month to month without a lease, so you basically have to be served on the first of the month, or the 30th of the previous month, and then you'd be out that month. If they serve you in the middle of the month, and you get the rest of that month, and then another month. So,
okay.
So if they served you today, for example, you'd be able to stay there in October, and you have to be out by the end of November.
Oh, okay. Now, I was served, she said verbally.
No, well, verbal doesn't work on anything in real estate, hardly.
Okay, so...
It has to be in writing.
And then she did it the first of this month, so I have to be out by the end of this month.
Yeah, if she gave it to you on the 1st, yes.
Okay, and it has to be in writing, right?
Should be in writing, yes.
Okay. Okay, that's all my question. Thank you.
All right, Mark, thanks.
All right, bye.
Let's go to Joseph in Jacksonville.
Yes, sir. I have a question about debt collection. I have a small business, and I have 2 outstanding invoices, and I'd like to know how much it would be if we could collect on these debts.
Are they under $5,000?
Yes, sir.
Well, you should go to small claims court.
They're out of state. One is in Illinois, and the other one is in Virginia.
Okay, so the person.
Can we send a letter? Could we send a letter to the companies trying to relinquish the invoices?
Well, certainly you can send a letter to collect your invoices out of state. You can send a certified letter telling them that you will take action. It's probably going to be in small claims court where they're located, though, and you're probably going to have an attorney to represent you for those, since you're suing a business and it's out of state.
Okay. How much am I looking at for something to be done like this? If I come to you, could you do something like this?
No, because we can't, sir. We're not licensed to practice in these other states or appear in court, nor would you want to pay the transportation costs for us to go there, even if we were.
I see. So I need to find
you need
a
to find a
lawyer in
local,
each state.
yeah, a local attorney in each state.
I see.
In the same county the business is, operated.
I see.
See,
all right. Yes, sir.
That would be the answer.
All right. Thanks.
All right.
All right. Bye-bye.
Okay, let's go back to JD. Hey, JD.
Hello. Yes. Thank you again for taking my call. I'm in a better location now.
Okay.
All right. The quick question is, I just finished a divorce, 16 years, and she was married previously, and she had a daughter. We never had any kids, but she got $200,000 from her father in his will, but she never put it into our account. She invested it. Okay, my name was never on anything, and she never put my name on the house. Okay.
All right, she got $200,000 that she kept separate prior to the divorce.
Prior to the divorce,
Mm-hmm.
okay, it was like several years ago, and she went to somebody that really knew, and she handled the money in the sense that she always claimed that her money was her money because her dad gave it to her even though we were married, and she never put my name on anything. And the house was paid off 3 years after we got married, and she claimed the whole house was hers. Yeah, she did give me some money, okay, and I settled basically out of court. I didn't fight it too much.
Were you
my
represented?
lawyer quit on me.
Oh, you?
Yeah.
Okay.
I had a lawyer,
Mm-hmm.
but because I was a nice guy, he was sorry about it, but he was money hungry, and he says, "No, I'll quit first before I put that in there," and I let him quit. So.
Okay. Well, generally, an inheritance received by your ex-wife, an inheritance received and kept separate, is not a marital asset subject to divorce.
Okay, I didn't have any problem with that. What about the house?
Okay, how did she get the house?
She had bought it herself when she was single, but she never put my name on it, but we were married for 16 years.
Well, the value, y'all didn't sign a premarital agreement or anything.
No.
The increased value from the date of marriage going forward, you probably could have made some kind of claim toward that. So, she paid $100 for, and you married 16 years, so it's worth $300. You might have been able to share somewhat in the equity of the property during the marriage.
Okay. Yeah, she did was she agreed to transfer of some of her 401k, which will cost me $1,000, and almost the same amount in cash that she's transferring when this divorce.
So
is
she
final.
made up for some of that.
Pretty much. Yeah,
well, yeah. If you will,
well,
if you agreed to it, if you agreed to all that, then you agreed to it. So.
Right, but was it? What would have been the Florida law if we would have been totally disagreeing on anything and we kept going to the go to the judge and say, hey, we can't settle agreement on this.
Yeah, well, but pertaining to the house, you can't just like cherry pick one little asset and expect me in a short conversation to come up with what the formula would be. So you really need a family law attorney to compute all that out for you. Okay.
And the other short question that I originally started with the co-op is, do you have any recourse when you're part owner of the park on the co-op and they say, oh, your trailer needs to be painted or you need to clean on something or whatever? If it's not written in the bylaws that you go to arbitration, do you have to take them to court?
Do you have to take them to court because they are trying to get you to do something that's not
right? Like
they're treating you differently than the other residents. There's nothing in writing about.
Well, they're being picky on the condition of the trailer. It's a judgment call, okay? But they say, hey, you got black marks on your driveway, or you got.
Well, yeah, if they would give you a letter to fix this pursuant to whatever they're going to reference, and if you don't do it, then it's because for us to evict you, and you can't work it out between the two of you, then yeah, it's going to always have to be settled in a court or with attorneys.
Yeah, I called the attorney that actually wrote Florida co-op laws, and he wouldn't take this case. Because he wanted money up front. And I'm thinking, wait a minute, we're going to countersue and see if you can get your payment. And he said, no, I wouldn't do it. I need $5,000.
Yeah, a lot of attorneys don't take cases like that on contingent basis, just, because you could spend a whole bunch of work on it and
not get anything.
Not get anything.
That's very different than a automobile accident.
Well, yeah, they only take those if they're, pretty sure they have a winning case.
Gotcha. Understood.
All right.
That's it. Thank you so much.
Thank you.
Bye-bye.
All right. We're almost 2/3 of the way. Well, not quite 2/3 of the way through the show. Let's say 40% through the show. Or maybe probably more than halfway through the show. But if you have a legal question, you can call our toll-free number, 877-943-9673. That's 877-943-9673. Phone lines are open. Are you involved in the middle of an estate and you don't think you're getting what you're entitled to? Think there's something going on that you have a little suspicion that the person that's handling it might be one of your siblings, could be another family member, could be a corporate trustee, and you don't think it's right? Hey, you have many, many rights as a beneficiary in an estate. You have a right to a full accounting. You have a right to have an inventory of the assets. You have a right to see how the money was spent. You have a right to see how your share was calculated. You have, and usually estates can't be closed till you have an agreement among the heirs that it's closed. So let's go to Robert in Clearwater.
Hey, how are you?
Good, Robert, and you?
Great. Just have a simple question. It pertains to an ex. Let's see, I put it this way. My current wife now, was married for 14 years before me to a guy that their parents had gifted them a down payment on their home.
Mm-hmm.
Now, the husband didn't really work, so often. So my wife actually paid half the mortgage, most of the mortgage, for about 12 years.
Mm-hmm.
And then,
but the house was in joint names?
No, that's the thing. I guess they left it in the parents' name. They said, we'll put a down payment, buy the house. So there's no...
Oh, and they let them live there rent-free?
No, they actually put the down payment on the home, and then they had to make the payments to it. But it was in the
they meaning the
parents' name. Yeah.
Who made the parents made the payments?
No. My wife and...
Okay,
yeah.
They made the payments. Okay.
Uh-huh.
Well, basically, that's a rent deal. I mean, the parents own the property, and the rent is making the payments.
Yeah, basically, that's what it looks like. But they said it was a down payment for their house. They bought it for them as a marital gift.
Well, they bought it for them. That's to live in, because they still owned it.
Technically, yes, that's the way it was. But it wasn't told that way. It was told that once it was paid off, they put it in their name. But they actually paid for it, so that she has no leg to stand on for anything. Probably.
Well, you're suing on words, and in real estate, it's hard to have a verbal agreement. It's not in writing, and it's real estate, and they were the owners.
Yeah, that's what I figured.
And unless there's something in writing that they promised to deed it over to them at the end of when all the payments were made, I would think you'd have to have something in writing.
That's what I figured. No problem. I appreciate your listening to us.
All right. Well, no problem.
All right. Thank you, sir.
Thank you. Listening to Ask an Attorney all about Florida law. Phone lines, we have one open line in anyway at 877-943-9673. Let's go to Steve. Hey, Steve, in Reddington Beach.
Yeah, a friend of ours is in the United States on a green card that does not work here, but she received a notification recently from the IRS that she needed to file some kind of taxes, and she doesn't owe taxes, but these are basically fines, and she's just checking with us to see if there's any recourse she has.
Well, I would advise her to take her fine letters to a CPA to look at them to see if that's valid or something can be done to be filed where she wouldn't have to pay a fine.
Okay.
That would be my advice, to get a CPA involved.
All right, I'll let her know.
All right, thanks.
Bye-bye.
Let's go to Jay in Bradenton.
Good morning. I have a Medicaid question this morning.
Okay.
Let's assume that we're not going to use John Fraser to do any kind of planning, and there is a $15,000 gift that's given from, say, my dad, and then we go in and try to work with the Medicaid program 3 years later. I understand there's a look back and that there's consequences for giving that gift, but how does it work? What is the actual consequence? What is, kind of educate me on the wrong way of doing things, if you want to call it that, just to see what is involved when they, take away that $15,000 worth of.
Well, they don't.
Gifts.
What they do is they so somebody's on Medicaid that you know.
Let's assume they're not to begin with, and that they say they have $115,000 worth of assets. They gave $15,000 away. Now they got $100,000 worth of assets, and they get sick and they need to start qualifying for Medicaid.
All right, so they have to report the $15,000 gift if they were to do this properly.
Okay.
And then they would be disqualified for receiving Medicaid. Let's say there's a divisor. I don't have the exact number memorized, but let's say it's $3,000.
Okay.
And they gave away 15, so they would be disqualified from receiving Medicaid benefits for 5 months. That's how it works.
Okay, so they take it into how many months, then that could be, so they just divide that in. Okay.
Now, sometimes a Medicaid attorney, like Mr. Fraser you mentioned, would get the gift reversed.
Mm-hmm.
And then it wouldn't be subject to the look-back period.
Right. So in that case, I would assume, say, if I were the recipient of the gift, I theoretically could give it back, and then everything would be back.
You could give it back, and then you could possibly then transfer the money to a personal service contract, which is not considered a gift, and still qualify for Medicaid.
Cool. All right. So basically, then they delay how many months? If they were going to be eligible in January, they postpone that a few months until their calculation.
Yeah, you'd be disqualified because of the gift, because there's a 5-year look-back period on any gifts.
All right, very good. And assuming the higher the dollar amount that you give, the more months that.
Yeah, there's a divisor. I just don't have the divisor memorized, but just for an example, it's 3,000, so you'd be disqualified for 5 months in your question.
All right, very good. Thank you for the info.
All right, thank you.
Bye-bye.
Let's go to Michael in Tampa.
Hi, thanks for taking my call. Briefly and to the point, I've got trees in the back of my property that are growing from an apartment complex. They're hanging over my lines. Tampa Electric has the idea that they won't come out and do anything until something actually happens as far as falling limbs and that sort of thing. In my front, I have a neighbor who has 3 big trees that are now have grown over my front driveway. I know that tree falls or if a limb falls on your property, it's your responsibility. But I'm just wondering, is there any way to, rather than approach these people and say, listen, I have a fear when my grandkids work, play in the backyard. They got falling limbs. Some of these trees are dead. Tampa Electric, again, I repeat, has the philosophy now that they don't cut anything for safety purposes until, like, we have a hurricane and it falls and we have no electricity. We went through the same thing in the hurricane where one of their trees fell, put out our electricity for 5 days. But the apartment complex is kind of non-responsive to that sort of thing. And I haven't checked with my neighbor, but is there any legal way I can ask these people to trim their trees?
Well, you can legally, of course, send them a certified letter telling them that their overhanging tree limbs are you consider a dangerous or in a dangerous position to cause harm to your grandchildren and other family members that might be close to them, and you request that they immediately trim them, or you will attempt to hold them responsible for any damage to your property or family. Now, let's say they ignore that. You do have the right to trim the trees yourself up your property line.
Yeah, I have done that up to a point, but the higher it goes, I can't find anybody that will fool around with the electric wires and the limbs. I guess unless it is Tampa Electric, many of the tree cutters will not go near those wires.
Yeah.
Anyway, that's my situation.
That's about your only choice.
Okay, a letter, and that should probably be certified, I guess.
I would send it certified,
okay.
So you have something on the record.
Just to see if
all right, thank you. Let's go to May in Tampa. Hey, May.
Good morning, Joe. Thanks for taking my call.
Well, my pleasure.
I have a question. I have a friend that has a lawsuit pending, and I had at one time had a lawsuit pending. I was able to get into account. Her situation, she has 2 little boys.
Are you fading out on me here?
Excuse me?
You're fading out on me.
Okay, just a minute. She has a pending lawsuit
against her.
And she, is there something like an escrow account that she can take money out of?
Ma'am, you're fading out on me. I can't really hear you. Maybe you should try to call back.
Oh, boy. Wait a minute. Hold on. Can you hear me now?
Yes.
Okay. Well, her lawsuit is pending. They said it's in the final stages. Is there an escrow account that she'd be able to take some money from this account? She's being evicted from the place. The lady wants to sell a house. And I'm just wondering, is there such a thing?
There's a lawsuit where she's being evicted?
Well, she's not. The lawsuit is from her being hurt. And they said it was in the final stages. And the lady that owned the house is selling the house, gave a 30-day notice to move, and she got to find somewhere to go with 2 little boys. And she called a lawyer, and we're trying to find out if there's such a thing as an escrow account that she might be obtaining money from the account before the actual payout.
Well, is the attorney received the settlement, a lawsuit settlement, and has cash in an the attorney already has some of her money in an escrow account? Is that the question?
Yes.
Well, you ask the attorney if he can release part of it so she can pay her rent.
Yeah, okay. All right. She just don't know where to go now, and I don't have the money to help her. So.
Well, if she's represented by an attorney and the attorney's received the settlement and hasn't released all of it, ask the attorney if he can release a partial amount so she can proceed. I mean, attorneys get personal injury money. It comes into an account. Then they're trying to settle up the last medical bills.
Mm-hmm.
So the attorney should know whether there's going to be excess money, and if there's going to be excess money left over, he might be able to release part. He or she might be able to release part of it.
Okay.
But you have to ask the attorney. Only the attorney handling the case would know that.
Okay. Yeah. When you got the secretary not letting you get through to him, that's the horse of a different color. So.
Well, tell him it's an emergency. To have the client call and say, this is an emergency matter, I need to talk to the attorney. Give me 5 minutes on his calendar sometimes to talk to him and try to do it that way.
Okay, Joe, we love you, and we're so thankful to have you.
Well, thank you.
So, that's why I called back, because I got
All right.
cut off the other time.
All right.
God bless you, and continue your good work.
Well, thank you, ma'am. Thank you. Goodbye.
Bye.
All right, we have about 10 minutes left in the show. If you have a legal question, you have a toll-free number, 877-943-9673. If I can help you in any way, give us a call. It doesn't really have to absolutely be a legal question. It can be just some problem you're facing, and maybe you just need somebody to talk to help get you out of the woods. 877-943-9673. Phone lines are open. And by the way, some of you are watching on Facebook Live. If you'd like to connect with me on Facebook, my Facebook, then I have 3 pages. The Law Offices of Joseph Pippen. We have Ask an Attorney page and my personal page. You can find under that Joseph Pippen, Pippen. If you want to connect with me there, I'd love to. If you want to connect with me on LinkedIn, you can find me there on LinkedIn. I'd love to connect with you there. On Facebook Live, you can watch us on Facebook. You can also watch us. They have a collection of the radio shows on Facebook Live on WeBeam TV. So you can go online and see, go to WeBeam TV. They have other many fine programs on WeBeam TV. And you can go back on a number of shows and watch pieces of them if you want to. Also, if you have an iPhone, we have an Ask an Attorney app that's free, and that houses many of our previous shows. And so it's Ask an Attorney, and it's on the iPhone, and that's a free app. Let's go to Tom in Jacksonville. Hey,
yes.
Tom.
I've got a company I've worked for 30 years. Next year I'm going to retire. I'm at a $2,500 a month payout for a pension.
Mm-hmm.
And the company's changing names, and somebody says through rumor they might take a pension away. Can they do that?
No, pension should be a protected amount of money. And when a company buys another company, they don't buy the rights to do whatever they want to with that pension money. It still has to be preserved for the employees.
Okay,
To give you peace of mind, you should go to your Human Resources Department and pose that question to them and get some confirmation that that money is being protected.
Yes, I asked them that question. They said they did not know the answer.
Well, they need to move. Tell them you were requesting they move the question up the line so you can have peace of mind, and tell them a lot of employees are worried about this, and nobody should be messing with your pension money.
Okay, thank you.
All right, thank you. All right, let's go to Diana.
Good morning.
Hey, Diana.
Yes, I'm in the middle of a custody battle with my grandson, and the lawyer that I have hired, I'm not very happy with. He doesn't do what he says he's going to do, and he doesn't return my phone calls. And what can I do about that?
Well, if you're not satisfied with your attorney, it's time to get another attorney, I would say.
Okay, but I've already paid him in full. So how do I just lose the money and restart over?
Well, you have a contract with him or her?
Yeah. Yeah.
Well, ask them that you're not satisfied. I would tell them you're not really satisfied with the way things are going, and you would like at least a partial refund so you can hire another attorney and see where that goes.
Okay. All right. Thank you.
All right. All right. Thank you. All right. You're listening to Ask an Attorney, all about Florida law. We have about 5, 6, 7 minutes left in the show. If you have a legal question, you do have time to call in. We have open lines right now at 877-943-9673. That's 877-943-9673. Phone lines are open. We're here to help you in the remaining moments, as we are every week from 8 to 8:52. If you've been listening, you know it's a straight 52 minutes of Ask an Attorney, no commercial breaks. That's the way I like it. In fact, that's the only way I'll do a show, actually. I don't do a show with commercial breaks. They do all the commercials at the end. So if you would like more information about our firm, we have a website, www.attypip.com, attypip.com. If you'd like our free estate planning poster sheet, if you'd like more information about estate planning, this would be a good good document for you to have. It's a large poster sheet on one side with 5 estate planning articles all about wills, trusts, doing nothing, options, consequences, charts, diagrams. It's really a very educational piece, I think, for anyone interested, whether you have a will or trust already. This would be a handy sheet for you to have. You can get that one of 3 ways. You can call our toll-free office number, 1-800-226-3529. That's 1-800-226-3529, extension 200. You can email me your name and address at Joe, J-O-E, at attypip.com. That's Joe, J-O-E, at attypip.com. Or you can text me your name and address at 727-667-3967. 727-667-3967. All right, let's go to Bert calling from, I'm not sure. Where are you calling from, Bert?
Sarasota, Florida.
Sarasota. What can I do for you?
Well, my daughter passed away a few years ago. She had an irrevocable trust. She was on Medicaid waiver, so the trust handled expenses not handled by Medicaid. At one point, Medicaid wanted a large sum of money from us from a settlement. We challenged that and actually won that situation, so that they didn't receive the money. But now that she's passed away, the money is just sitting. The remaining money sits, and they've been notified of her passing 4 years ago, and they haven't touched it yet. Is there? Can we legally access that money, or does that money have to be hands off, and eventually one day they're going to get it?
I think I'd probably have to see the trust before I could answer that.
Okay.
So how much money's in the trust?
Probably now it's down to about $30,000 from its peak, so there's just about $30,000's been sitting in there. And the trust was set up so that her passing, any remaining monies would go to Medicaid, the typical irrevocable type trust for that situation.
Yeah, well, if that's why it was set up and that's what the trust says, that's what you'd have to do.
Okay.
Who's the trustee?
Trustee is myself and my wife.
Yeah, if you open up a probate, if the trust says that, the trustee's obligated to do what the trust says. Number one. So if the trust says that upon her death, she put this money in a trust so that she could qualify for Medicaid, but if there's any money left in the trust upon her death, it goes to the state. That's what that's what you'd be obligated to do.
Okay, I was wondering if there was a statute of limitations on the state for taking that money, but there's not then.
Well, if there was a probate estate, here's what happens. If you open up a probate estate after she died, the state then would file a claim against the probate estate because they've been noticed that she had passed away. So if you sent the state a copy of the trust and try to negotiate with them, you might be able to save some of the money. But if the Medicaid claim would be larger than the amount of money in the trust, that would probably be a tough battle. Yeah, it'd be a tough battle, I think.
All right. Well, just wondering that. Thank you very much, sir.
All right. Thank you. You're listening to Ask an Attorney all about Florida law. We are here every week during this time period. If you have friends that have legal issues, something they're very, very concerned about, something you're concerned about, you want to know what your rights are, want to have a little peace of mind, it wakes you up in the middle of the night worrying about it, hey, Ask an Attorney all about Florida law. We're here every week during this time period to help you. Again, if you would like our free estate planning poster sheet, you can get that one of 3 ways. You can call our toll-free office number, 1-800-226-3529. That's 1-800-226-3529. If you want to check out our website, it's www.attypip.com. If you want to email me your legal question or the request for the poster sheet, you can do that at Joe, J-O-E, at attypip.com. And if you want to text me, it's 727-667-3967. Again, you have a wonderful weekend. Be safe out there. Join us next week at the same time for more Ask an Attorney all about Florida law. So long.
Pastor coming